5 seconds to go. Start. Provided further that nothing contained in this act shall be deemed to empower the rent tribunal to entertain a petition involving such dispute between landlord and tenant, to which provisions of the Rajasthan Public Premises Eviction of Unauthorized Occupants Act 1964, Act number 2 of 1965, and the Rajasthan Premises Requisition and Eviction Ordinance 1949 apply, where the petition only for recovery of unpaid rent or arrears of rent is filed, the time schedule and procedure enumerated in section 14 shall mutatis mutandis apply to such petition, where the petition for recovery of possession is filed in respect of the premises or tenancies to which the provisions of chapter 2 and 3 of this act do not apply. The time schedule and procedure enumerated in section 15 shall mutatis mutandis apply to such petition. A petition shall be instituted before the rent tribunal within the local limits of whose jurisdiction the premises is situated. Arguments advanced by Ms. Kasliwal at the first flush appear to be attractive, and one can form an opinion that the rent tribunal has the jurisdiction to order eviction only in contingencies enumerated in clause A to M of section 9 of the Act of 2001, and if there is any other ground for which eviction is sought, the landlord has to approach a civil court. But a close and conjoint reading of sections 9 and 18 of the Act of 2001 debunks such misconception and suggests otherwise. Section 9 of the Act of 2001, which begins with a non-obstant clause in no ambiguous terms, provides that subject to anything contained in any other law or contract, in case the provisions of section 9 of the Act of 2001 are applicable, the rent tribunal shall not order eviction of a tenant unless it records a satisfaction of presence of the contingencies situations encapsulated in clause A to M of section 9 of the Act of 2001. But then section 9 of the Act is not the only repository of powers of the rent tribunal. There are other provisions which convey powers or jurisdiction upon the rent tribunals. Section 18 of the Act of 2001 is so worded that while it creates a complete embargo on the civil court to deal with disputes between a landlord and a tenant, simultaneously it confers a jurisdiction upon the tribunal constituted under the Act to try all disputes between them and matters connected therewith and ancillary thereto. Such being the position, the applicability of the Act of 2001 cannot be said to be restricted to the petitions that are filed under Chapter 2 and 3 of the Act of 2001. All matters concerning a landlord and tenant or any other ancillary dispute are required to be tried under the Act of 2001. A careful reading of subsection 3 of section 18 of the Act of 2001 steers clear of even slightest of doubt, inasmuch as it clearly provides that when a petition for recovery of possession is filed in respect of premises or tenancy to which chapter 2 to 4 of the Act of 2001 do not apply, the time schedule and procedure prescribed under section 18 of the Act of 2001 would apply. Hence, it is crystal clear that a petition for recovery of possession can be filed in case of any other premise or tenancy which is not governed by chapter 2 to 4 of the Act of 2001. If the intention of legislature was to confine jurisdiction of rent tribunal to the cases governed by clauses A to M of section 9 of the Act of 2001 only, then there was no occasion for inserting subsection 3 in section 18 of the Act of 2001. In the case in hand, as the lease was for a period of 11 years, it is not governed by section 8 of the Act, hence chapter 2 and 3 of the Act of 2001 are applicable. As a corollary of discussion foregoing, this court is of the considered view that jurisdiction of civil courts to deal with any matter, the case or the dispute between the petitioner and respondent is required to be tried and decided by the rent tribunal only. My aforesaid view is fortified by the following judgments, relevant part whereof is reproduced hereinafter. Nalini Mehta versus SBI Supra, having given a thoughtful and anxious consideration to the rival submissions and having examined the scheme of the Act of 2001, this court is clearly of opinion that the impugned order proceeds on total misinterpretation of the plain provisions of law and cannot be sustained. The Rajasthan Rent Control Act 2001 is to the provide for control of eviction from letting off and rents for certain premises in the state of Rajasthan and matters incidental thereto. The Act has been divided in 7 chapters under the heads Preliminary, Revision of Rent, Tenancy, Restoration of Possession of illegally evicted tenant and procedure thereof, Constitution of Tribunals, Procedure for Revision of Rent and Eviction, Appeal and Execution, Amenities and Miscellaneous. Section 1 of the Act clearly provides that it extends in the first instance to such of the municipal areas which are comprising the district headquarters in the state and later on to such of the other municipal areas having a population exceeding 50,000 as per 1991 census, as the state government may by notification in the official gazette would specify. Subsection 3 of section 1 provides that this act would come into force with effect from such date as may be appointed by the state government by notification in the official gazette. The state government has appointed 1st day of April 2003 as the date on which this act shall come into force, and it shall extend to all the municipal areas which are comprising the district headquarters. Stop.